Welcome to Lessons from the Serial Case, 10 Evidentiary Missteps You Want to Avoid. My name is Tom Hagee with HB Litigation Conferences. This was a complimentary webinar produced by LexisNexis on August 18th of 2015. Before I introduce our presenters, I thought I'd give you a little background on the case they'll be discussing. It is the subject of a wildly popular podcast called Serial, which was a spin-off from the This American Life podcast and radio show. It also spun off from that another podcast called Undisclosed and another one called Serial Dynasty. I won't go into too much detail, but I'd encourage people listening to this recording to go back and listen to Serial, listen to Undisclosed, and listen to Serial Dynasty. Not only are they interesting, but they're extremely well done, thoroughly researched, but they shine a bright light on many of the problems that exist in the criminal justice system in courts throughout the country. The case is called Maryland versus Adnan Syed. It starts off with tragedy. Hae Min Lee, who was a Woodlawn high school student, Woodlawn's in Maryland, it's in Baltimore, and by all accounts, Hae had a bright future. She was loved and popular and athletic and intelligent. She went missing on January 13th, 1999. Her body was found partially buried in Leakin Park. She was murdered by strangulation. Hae was 18 years old. Despite a lack of physical evidence linking him to the crime, her friend and ex-boyfriend Adnan Syed, 17, was charged with her murder. DNA evidence gathered at the crime scene was never tested. Based on the testimony of one person who claimed to be a witness, Jay Wilds, and presentation of cell phone records, Adnan was found guilty. He remains in a Maryland prison today. Syed recently was granted permission to present testimony of an alibi witness who, despite coming forward, was not called to testify. Believing he was wrongfully convicted, the Syed family friend, Rabia Chowdhury, also an attorney, persevered on Adnan's behalf in the courts and in the media. Sarah Koenig, a former Baltimore Sun reporter, picked up the story for WBEZ's This American Life radio show and podcast. She then spun the story into this, as I said, wildly popular podcast that was simply called Serial. The podcast raised awareness of the case and myriad questions about how it was handled by the police, the prosecutors, and by Adnan's own attorney, Cristina Gutierrez. Gutierrez, it should be noted, was suffering from multiple sclerosis while handling Adnan's case, and the two trials, the first ended in mistrial. She was also engaged in behavior that led to her disbarment. She was described at one point in the Baltimore Sun as a once tough and skillful trial attorney. So after her disbarment, 2 years later, she died in 2004. She was 52. When the Serial 12-part series concluded, Chowdhury and two other attorneys who had been blogging about this case picked up the story, but with a laser focus on evidentiary issues. That podcast is called Undisclosed, and those two attorneys are our presenters today. First is Susan Simpson. Susan is an associate with the Volkov Law Group in D.C. In this role, she represents clients in all phases of civil and criminal litigation. Her trial experience includes a wide range of commercial litigation matters, including the successful representation of clients in both bringing and defending actions for breach of contract, commercial torts, defamation, civil conspiracy, fraud, and infringement of intellectual property. She also has experience in civil and criminal appellate litigation before state and federal courts. During law school, Susan represented George Washington University Law School in a number of moot court competitions, including taking first place in a moot competition for international law. After graduating with honors, Susan spent 4 years as a civil litigator in Virginia before leaving to join the appellate division of the U.S. Attorney's Office for the District of Columbia as a special assistant U.S. attorney. In this position, she handled all stages of appellate proceedings and appeals from felony and misdemeanor convictions involving a variety of legal issues, including constitutional claims, evidentiary challenges, standards of review, affirmative defenses, and post-conviction proceedings. Today she focuses on representing clients in investigations and enforcement actions, as well as with related civil proceedings. Additionally, she assists corporations in anti-corruption and regulatory compliance matters. Joining Susan on this webinar was Colin Miller. Colin is an Associate Dean of Faculty Development and Professor of Law at the University of South Carolina. Law School. Previously, he served as professor at the John Marshall Law School and was a visiting professor at the William & Mary Law School. He's the creator and blog editor of Evidence Prof blog, which addresses recent developments in evidence, precedent, legislation, and scholarship. His areas of expertise include evidence, criminal law and procedure, and civil procedure. Colin's a graduate of William & Mary Law School, where he served on the William & Mary Law Review and the William & Mary Bill of Rights Journal. Susan and Colin, joined by Rabia Chaudhry, are the three attorneys who are the hosts of the Undisclosed podcast, which is examining this case and will soon examine others. The first voice you hear will be that of Colin Miller.
All right, today we're going to focus on 10 different topics, looking at evidentiary mistakes that attorneys might make at trial based upon what transpired at the trial of Adnan Syed. The first of these topics is the overuse of stipulations by an attorney. Now, stipulations, as I'm sure all of you know, are an agreement between one side and the other in a case. Trials are all about disputed issues, and in any case, you're going to have a number of undisputed issues. So, for instance, you might have a defendant charged with being a felon in possession of a firearm, and in that case, of course, defense counsel is going to stipulate that the defendant has a prior felony. You might stipulate to the credentials of an expert. So it might be an arson case, and it's clear we have an arson investigator, many years in the job. He's fairly well qualified. In that case, defense counsel is going to stipulate we have an arson expert who can testify in the case. Now, the problem in the prosecution of Adnan Syed, and you can see we have this slide up where defense counsel basically overstipulated. She stipulated to basically tons of evidence that was very much disputed and arguably would have been deemed inadmissible at trial if a proper motion in limine or an objection were made in the case. The first of those pieces of evidence to which defense counsel stipulated that is really troubling, and that's the diary of Haymon Lee. This was a murder prosecution. As we discussed before, Haymon Lee was the murder victim in the case, and if you're defense counsel, basically the last thing you want to do is to have the victim speak from the grave. But that's exactly what happened in this case, because defense counsel stipulated the admission of the entire diary of Haymon Lee, despite the fact the prosecution was only seeking to admit limited excerpts. And in fact, if you look at both the opening and closing arguments at trial, the prosecution placed heavy reliance upon the words that were written by Haymon Lee. And it seems, in fact, that in a case short on evidence and long on narrative, it played a large role to play in the conviction. Now, if you look at it from an evidentiary perspective, the diary in this case probably should have been deemed inadmissible for a number of reasons that could have been raised by defense counsel. We have the rule against hearsay, and while there are exceptions for present sense impressions and for statements that show the state of mind of the speaker, that often doesn't apply in diaries where it's tough to say how long after an event the person wrote the diary entry, and in fact, there's precedent in Maryland deeming diaries inadmissible. In addition, this diary evidence was cumulative of other evidence at trial. It dealt with past events, it didn't deal with current feelings, and for several reasons, defense counsel could have and should have objected, but instead, as noted, she stipulated, which meant not only could the diary come into evidence, but it couldn't form the basis for an appeal. In fact, the appellate attorneys in Adnan's case tried to argue this diary was extremely prejudicial and should have been excluded at trial, but based upon the stipulation made by Gutierrez, there was no success. And so, Susan, beyond the diary, what other pieces of evidence did the defense stipulate to in this case?
And just to be clear here, we're not trying to discourage anyone from making stipulations in a trial. They're useful, they have a point, and there's nothing more annoying than when you have an opposing counsel that's going to pick fights over things that don't need to even have time wasted on them. In this case, though, Gutierrez consistently let evidence in without objection when she easily could have kept it out. The result was quite detrimental to Adnan's case, and, for instance, with regards to the forensic evidence, although it's normally admissible, in this case, there were some serious problems with the reports and records of the state's crime technicians. However, because Gutierrez stipulated the admission of these documents, that evidence came in without her being able to challenge it or to question these irregularities. On this slide, you'll see some examples of inconsistencies and problems in the forensic reports. For instance, the shirt that Hay was found wearing is described differently in every single report that was ever filed. It's either a gray shirt or a blue ribbed blouse, or some combination of the two. It's not clear what the shirt really was, but when you're getting into fiber evidence and comparing fibers that were found, trying to figure out what clothing items those fibers were obtained from is important forensic evidence. These things were not clarified at trial. We also had issues with, for instance, an initial report finding that there were no fibers at all in the crime scene, and then later a substitute report that found the opposite. Now, this is just the forensic evidence. Gutierrez decided to stipulate things like Don's work records, such as where he was on January 13, 1999 at the time of Hayes' disappearance. Even though there were some irregularities with those time records that the prosecution didn't point out and which the defense could have used to show that Don's alibi was not solid. As you can see here, even LensCrafters, Don's employer, seemed to have questions about the nature of the time records and where they came from. In fact, the paralegal who provided the records wrote to Kevin Urich, the prosecutor, and noted that those time records were from the store where Donald's mother was the general manager, which the paralegal actually noted in bold in her letter, perhaps bringing attention to that fact. And it's a big deal, because the general manager has power to alter or edit time cards. All of this could have been effectively used at Anand's trial to help his defense in a number of ways. But again, because these issues were never challenged, never brought up, because the defense simply allowed this evidence to come in without challenge, Anand never had a chance to use it. The next issue, and probably I think the biggest in this case, is expert witnesses and how they were handled at trial. Colin, would you agree with that?
Yeah, I definitely agree, and we'll discuss both the cell tower evidence and the pathology evidence later, and I think we would both agree that these two types of evidence were possibly the linchpin of the state's case, and if Gutierrez had properly consulted with and then called experts at trial, those foundations of the state's case basically would have been dissolved.
Yeah, the two main problem areas here were with the pathology and the RF engineer. The first has to do with the autopsy results, and the second with the cell phone evidence, which was used to show, as the prosecution argued, that Anand was in Lincoln Park at the time that Hay was being buried. In fact, neither of those things may be true, but due to the lack of experts called by the defense, none of this was ever presented to the jury. To break this down a bit, there are two problems here. The first is that Gutierrez didn't do enough to keep out the state's experts, or to keep out the problematic parts of their testimony. The second part is that Gutierrez didn't do enough to get her own experts in, or to even consult with experts, in order to prepare for trial and to assist Anand's defense. With regards to objecting to experts, she did object to one expert that the prosecution brought, so she wasn't totally asleep at the wheel here. She managed to have the school's nurse's testimony excluded, which the prosecution was trying to introduce to show that Anand was allegedly faking a catatonic state at the time he learned of Hayes' death. So she got the nurse's testimony thrown out because there was no valid basis for it. But what she didn't do was adequately question the state's medical expert, the person who performed the autopsy, in order to show that there are problems with the state's autopsy report and its conclusions about the time of death and the burial time. Nor did she bring her own expert to challenge those conclusions. Colin, if she'd done that, what might the jury have heard?
Yeah, we've talked about this on the podcast. I've written about it on my blog. We've both consulted forensic pathologists. There's a process after a person dies. It's known as livor mortis. Basically, when you're alive, your heart is pumping blood. It's flowing throughout the body. When you die, your heart stops pumping. The blood starts to settle into the tissues, and it settles into the dependent portion of the body, in other words, the lowest portion of your body. This is a process that's known as lividity. That lividity starts to become fixed about 2 to 4 hours after death, and it becomes fully fixed about 8 to 12 hours after death, meaning that even if you move a body after 8 to 12 hours from, say, its back to its front side, the blood is not going to move because it's settled into the tissues permanently. Now, in this case, you might recall the prosecution said that Heyman Lee had been killed by 2:36 p.m., that she was then pretzeled up in the trunk of her Nissan Sentra for the next 4 or 5 hours, and then subsequently buried in Lincoln Park during the 7 o'clock hour. When her body was eventually disinterred, it was found on its right side. Well, the problem with that is the lividity in Heyman Lee's body was fully fixed on the front, the anterior of the body, which means both A, she couldn't have been pretzeled up on her side in the trunk for 4 to 5 hours, and B, she couldn't have been buried in her right side in the 7 o'clock hour. Problem for Adnan is, in this case, Gutierrez did not hire her own medical examiner. She didn't properly cross-examine the state's medical examiner. And as far as we can tell, it's not the only case where Gutierrez had this problem. In fact, we had an episode that aired just last night where we talked about a case that, in fact, was just reversed. It was the Richard Nicholas case. And in the Nicholas case, there were validity issues as well. In fact, the prosecutor's office told the medical examiner the validity issues were central and key to the case, and they were very much disputed conclusions the expert had. And in that case, Gutierrez also did not call a forensic pathologist or in any way contradict the state's findings during her cross-examination of the expert. Now, this is really important because a huge part of the state's case is that Hay was buried in the 7 o'clock hour in Lincoln Park. And Susan, the reason the state claims this is we have these 2 cell tower pings in the 7 o'clock hour.
Yeah, it was kind of a two-part issue here, too. The prosecution needed to show that Hay was buried at 7 p.m. because that's the time their cell phone evidence, at least according to their interpretation of it, showed that the phone was there at Lincoln Park. I won't get into too much detail here. We've gone into a lot of detail in the podcast for anyone who's curious. But if Gutierrez had consulted with her own expert for the cell phone evidence, she could have done a much better job in explaining what the evidence did and did not show. More importantly, experts are there to help attorneys prepare for trial, not just help them at trial. Although experts are important for the jury, they're also important just to help the defense understand what the evidence was and what the problems with it are, even before you ever get to trial. It's possible that if Gutierrez had had a defense expert, she would have been able to learn or find out that AT&T did not consider incoming call location data to be reliable. Now, the Lincoln Park calls were both incoming calls, so if that evidence is not reliable for location, like AT&T says, then the state has nothing to show that Adnan had actually been at or near Lincoln Park at 7 p.m. And even the fact that the validity evidence shows the burial time didn't happen then either is strong evidence that the state's case was bogus. If Gutierrez had called these experts and if she appropriately approached the evidence, the defense could have shown that the prosecution's case involved Adnan being somewhere where a crime wasn't going on, and nothing more. Moreover, if she'd gotten a cell phone expert, the cell phone expert could have explained to her why this evidence should have been excluded in the first place and why it never should have been an issue before the jury from the beginning. Now, Colin, I know that Maryland doesn't follow the federal rules here. What standard do they apply in determining whether or not evidence gets in?
Yeah, so the Supreme Court in the Daubert case installed the idea of a judicial gatekeeper and had a new test for expert evidence. Maryland, though, at least at the state level, still applies the old Fry test, the general acceptance test, and I think consistent with what Susan said in the wrap-up on the stipulation section, by no means do you need to consult an expert on every single issue involving scientific or technical knowledge. That's because many issues have been resolved, and therefore there's no need for a Daubert hearing or a Fry hearing. And in many cases, you have limited resources. You have to decide where to focus them. But certainly in a case like this, where really the crux of the state's case is these cell tower pings, the burial in the 7 o'clock hour, they have a cell tower expert, they have a pathologist. In that type of case, it's really incumbent upon you as an attorney to make sure you're getting that expert advice, whether it be consultation, whether it be them testifying, it just in some way helping you to understand and use and maybe attack the expert evidence at trial. And that takes us to our third topic, which is knowing the record and being able to, when appropriate, impeach witnesses. Because I'm sure you know when you get to trial, that's not the first time the people taking the witness stand are making statements. Instead, oftentimes, there will have been depositions, interrogatories, testimony at a preliminary hearing, a grand jury, etc. Therefore, it's really important when you're interrogating a witness, especially a fundamental witness who's important to the theory of the case at trial, that if they've given testimony inconsistent with their prior statements, you're ready to either refresh the recollection or, when appropriate, to impeach them based upon inconsistencies. Now, we can see a few examples of this in the Adnan Syed trial. I'll deal first with Debbie, and then Susan will deal with Coach Sy. Now, Debbie, as an introductory slide showed, was a friend to both Hay and Adnan. You recall that I said in the prior topic, the state said that Heyman Lee had been killed by 2:36 p.m. And in both police interviews on March 26th, and in fact in testimony at Adnan's first trial that ended in a mistrial, Debbie consistently said at about 2:45 p.m. on January 13th, I saw Adnan at the guidance counselor's office. And in fact, we have some corroboration for that because we know his guidance counselor testified at trial that she gave him a letter of recommendation that was dated January 13th, which again was the day in question. So when Adnan's second trial rolled around, Gutierrez was interrogating Debbie and asked, as you might expect, do you recall telling police officers about seeing Adnan at the guidance counselor's office at about 2:45 p.m.? All of a sudden, though, Debbie, for whatever reason, no longer recalled making that statement. Well, again, in a case like that, it's incumbent upon defense counsel to be able to either A, refresh recollection. She could have shown Debbie her prior police interview. She could have showed her the testimony from trial one. And if that worked, great. Debbie could say, yeah, I recall making that statement about seeing Adnan at 2:45, which of course would directly rebut the state's theory that Hay had been killed off campus by 2:36 p.m. And then B, if Debbie, after being shown the statement, did not have her recollection being refreshed, at that point, Gutierrez could have impeached her through her prior inconsistent statement. And in fact, beyond that, under Maryland law, if a prior inconsistent statement is made during a recorded police interview, it's defined as non-hearsay and it's admissible to prove the truth of the matter asserted. So in this case, when Debbie said, I no longer remember making that statement, Gutierrez could have introduced her prior police interview and her prior testimony to show, A, her testimony at trial was lacking credibility, but B, more importantly, here is an alternate theory of the case which shows that the 2:36 timeline makes no sense, and that seems like reasonable doubt. Now, Susan, I've covered Debbie. What about Coach Sy, the track coach in this case?
And just on Debbie, though, she's probably one of the most frustrating parts of this case because she has clear statements saying that she saw both the victim and the defendant on the day in question and the time in question, and if her stories are correct, there's no possibility that Adnan could have committed the murder. Unfortunately, she was never effectively used by the defense to blow up the state's timeline, which she could have been used to do had Gutierrez been on the ball. Coach Sy, though, is another example of where the defense's failure to know the record and to know the contents of the witness's prior statements caused the defense to lose a valuable opportunity to establish an alibi. Now, Coach Sy was the track coach at Woodlawn High School, and Adnan was on the indoor track team during the fall and early spring of 98-99. Although Coach Sy said he couldn't tell for sure if Adnan had been at track on January 13th because they didn't take a roll, he did give statements to the police which, by process of elimination, did show that he remembered seeing Adnan at track on a day that could only have been January 13th, because based on his descriptions, there's no other day that fits. But not only did Gutierrez fail to bring out that Adnan was at track that day, she also failed to bring out when track started and why Adnan had an alibi from about 3:30 p.m. onwards to the end of track around 5:30, 5 o'clock. Again, in Coach Sy's police statements and also in a statement that he made to the defense investigator, he stated that he usually got to the field at about 3:30 p.m. and that the kids would come to practice after study hall, which ended at 3:15 p.m. Coach Sy also said that if they were late from study hall, that would get dealt with. So he would notice if someone was late, and he would notice if someone left early. And according to him, Adnan did either on the day that has to be the 13th. If Gutierrez had been able to bring up Coach Sy's previous statements and question him with it, she could have gotten him to testify that, yes, as he previously stated, the kids went to track right after study hall, and he got there at practice at 3:30 p.m. That didn't happen. Gutierrez let it drop, and another alibi that should have been a strong point in the defense's favor simply fell away. Now, obviously, these are not the only instances where there are failures at trial, and it's hard to see a lot of the time what preparations Gutierrez could have done for the witnesses if she'd actually done prep work, because she consistently fails to bring out points on testimony which should have been vital for the defense, like with witness Becky, another friend from Woodlawn High School, who says that she saw Tay tell Adnan that he couldn't get a ride that day.
Right, it's a fundamental part of my theory of what happened on January 13th that in her police statement, Becky says at the end of the school day, Hay said to Adnan, I can't give you a ride because I have something else to do. Now, we have independently confirmed through another witness, Krista, a friend of Hay and Adnan, that she was told by Hay's best friend Aisha that on January 13th, she was privy to the same conversation where Hay turned Adnan down for a ride because something had come up and she had somewhere else to be. Now, there's both knowing the record and developing the record, and in this case, it seems Gutierrez was unprepared to develop the testimony of Becky on this point, and that she was also completely unaware that both Aisha and Krista apparently had this knowledge, and therefore she was unable to develop this theory. Now, the state's case was basically that Adnan had requested a ride in the morning. At the end of the day, Aisha was talking to him, and then she immediately left the school. What the defense then desperately needed in this case was something to show that this ride didn't take place, and it was right there in Becky's police statement. It was there in the memories of other witnesses, and yet it was never used at trial.
Yeah, so we have two different witnesses that both saw Adnan and Hay walking in different directions after school ended, but none of that ever came out at trial. Now, the next topic is objections during closing arguments. In closing arguments, parties are generally given a great deal of leeway, and the prosecution in a criminal trial, according to established case law, is entitled to considerable latitude in summation. So they're allowed to argue that the evidence and any reasonable inferences that can be drawn from that evidence can be interpreted in their favor. However, what this latitude does not allow for is for the prosecution to make false and factually unsupported claims. However, it's generally best to be somewhat cautious and reserved in making objections during closing arguments, because oftentimes courts are going to be very patient with an attorney that's engaging in some puffery and dramatic license in his closings and opening. So you don't want to object to every, slight stretching of the facts. But in this case, there were many, many misstatements made in closing that Gutierrez could have and should have objected to, and she simply missed. So in order for a statement to be a misstatement in closing arguments, it has to be an actual statement of fact. Because inferences can be drawn, the prosecutor is entitled to say something that may not be factually true, but a reasonable person could have concluded after looking at the factual evidence. But what they can't do, and what they did in this case, was to present evidence that either never came in the first place or was simply contrary to the actual record at trial. Let's look at some of the objections that can be made during closing. Some of the major ones are arguments and comments from the prosecutor that are unduly prejudicial or inflammatory, such as appeals to racial, ethnic, religious, or gender prejudices, the use of inflammatory language and inflammatory comments directed towards other attorneys or other parties and witnesses. You can object to improper arguments for facts not in evidence when someone cites to a factual point that was never actually developed at trial, or you can object to misstatements of facts and misstatements of the law. An objection can also be raised if someone in closing arguments states personal beliefs about the merits of the case. Attorneys can't do that. There are also objections that can be made to references to improper subject matters. Now, in a civil trial, this would be something like discussions about insurance coverage or settlement discussions, things that you can't put in front of a jury. In a criminal trial, it would be things like the right to remain silent. A prosecutor can't reference a defendant's failure to testify at a court because the Constitution protects the defendant's right not to testify. In this case, some of the improper closing arguments we had included things like factual claims that were contrary to the record, like the wrestling match. In closing arguments, the prosecution claimed that Hay was going to be the manager at a wrestling match at Randallstown that day. This is important because, according to the prosecution and a note found in Hay's car, Hay had been going to see Dawn that day, but she couldn't make it because she had a wrestling match instead. And that wrestling match, according to Hay's note, was at Randallstown. However, it turns out that there wasn't actually a match at Randallstown that day, and the prosecution simply made a mistake about the fact, or assumed it was a fact, based on a note they found, when in reality, there wasn't a match at all, no witness testified there was a match, and the only witness who mentioned a match named a different school entirely.
Yeah, and another claim that the prosecution made during closing, and I think this is pretty essential in selling the case to the jury, was that other than the victim's, Heyman Lee's, fingerprints in the car, the only other fingerprints that were found in the car belonged to Adnan. Not especially surprising, given that he had been in the car quite often and was Hay's ex-boyfriend for several months. The problem with this argument, though, was that it was factually untrue. In fact, as we've discussed in the podcast, more than 20 other prints that were found in the car were not identified. Now, you can draw reasonable inferences, but you can't misstate the expert evidence in the case, and this was clearly a fundamental misstatement. Another misstatement that's not there on the slide was that you might recall in the Route Talk episode of Serial, Sarah tried to retrace the prosecution's timeline of Hay leaving the school and getting to Best Buy in time for Adnan to be able to make the come and get me call to Jay at 2:36 p.m. Prosecution's claim during closing is that strangulation takes only 10 seconds. Well, that's actually not what the medical examiner testified to. In fact, it takes several minutes to fatally strangle someone, and this was a fundamental misstatement of fact. Basically, the point is that after about 10 seconds, the person can become unconscious, but that's not enough for the person to be fatally strangled. And when the prosecution fundamentally misstated this fact during closing, it made it much easier for the jury to believe that the state's timeline held water, when in fact there were quite a few holes in it that could have been poked.
We also have claims the prosecution made, and that I would argue are likely untrue, that are based upon evidence of a sort, but which were improperly based on evidence that hadn't actually been brought into the record. Now, we also have claims made in closing arguments that I would argue are probably factually untrue or unlikely to be true, but they're based on evidence and were proper arguments to be made in closing arguments because they were inferences that could be drawn from the evidence. For example, the prosecution claimed that Hay was in the passenger seat of her car at the time that she was attacked and killed. That was reasonable. The prosecution was allowed to take evidence and draw an inference based on it. There's actually some issue here about the underlying evidence to support the prosecution's claim that Hay had been in the passenger seat of her car, and that concerns the windshield wiper versus the turn signal debate, which we'll get into in a little bit. But since that evidence was in the record, the prosecution was properly making this claim during closing. Another example of an inference that could be drawn by the prosecution was that the 2:36 p.m. call was the come and get me call. Just to remind you, the 2:36 call is the call that the state argued was Adnan calling from Best Buy to Jay to say, "I've killed her, come and pick me up." But no one ever actually testified to this at trial, because Jay insisted that call didn't take place until about 3:40, 3:50 p.m., so over an hour later. However, even though no witness ever claimed that 2:36 p.m. was the come and get me call, and even though there was some evidence which would strongly conflict with this possibility, the prosecution was allowed to make this argument during closing.
Yes, Susan, overall, I think it's a pretty fine line that we're discussing here, and even as you noted yourself, some of these claims, while they might have been misleading, they were proper and could be made by the prosecution, and you don't want to be that attorney who's there during closing constantly objecting, because it's tough to have objections sustained during closing, and it could also anger the judge if you are constantly raising these objections. At the same time, closing argument is very much about framing the issues to the jury. It's about putting everything together to the jury and being able to say, here is how everything fits together. And if the other side in the case is framing things in a way that doesn't match up with the evidence, that's something that justifies an objection, because you don't want the jury to have the last thing that they hear not match up to the evidence and basically overstate the case against your client.
Gutierrez did object some in closing arguments, but it probably, if anything, backfired on the defense. The problem was that she made all the wrong choices when it came to what battles she wanted to fight. She wouldn't comment on things like the prosecution's false claims about fingerprints, or about how the prosecution claimed that Hay's diary said things it didn't, because all that came in without comment from Gutierrez. But she did make objections to things that were somewhat nonsensical and probably did nothing other than to irritate the judge and to draw the jury against her client. For example, at one point, the prosecutor said that Adnan had been arrested on February 24th. And that's when Gutierrez starts jumping in to object and say, no, he was arrested on the 28th instead. Well, that's true. The arrest date was the 28th, not the 24th. But that's not really the point. And those kind of objections aren't going to get you any ground and will do nothing but be off-putting to the jury. She also made another objection in which she claimed that the prosecution had made improper references to Adnan's ability to testify. But they hadn't. That actually didn't happen during closing, even though Gutierrez strenuously argued that it had. Although the prosecution had brought up other witnesses who hadn't testified, Gutierrez was either making a somewhat odd strategic choice and trying to willfully misinterpret the other side's statements to gain some points, or she simply hadn't followed along with the state's arguments and wasn't aware of who the state was actually referring to when it made those references to witnesses not testifying. So the objections she was making weren't good objections, and she was letting in stuff that was very much objectionable and she should have made noise about. Now, the contemporaneous objection rule applies also to objections during closing and opening arguments, and not just to testimony during the case in chief. So that's something else to keep in mind here. This rule requires that an objection be made at the time of the event that's being objected to. And in order for an objection to be properly preserved, the attorney needs to make the objection as soon as practical, make it a formal objection on the record, and to let the trial court have a chance to fix it first. Gutierrez failed to comply with this rule because at other points she did object, sometimes to testimony or statements that she rightfully should have objected to, but she wouldn't say why she was objecting. She would simply state objection, and the court would say overruled, and close the arguments down and move on without ever developing the record. This did not preserve the record for appeal, and even though those objections were valid, they could not have been raised thereafter at appeal because the court had never had a chance to try and fix it before it was reviewed by the appellate court.
Yeah, I think, Susan, definitely this prior topic ties in with this one in the sense that knowing the record is fundamental to being able to object during closing. You mentioned the Randallstown wrestling match and how that took place on January 5th instead of January 13th. I mentioned the fingerprints. Part of that might have been that Gutierrez wasn't paying attention during closing. Another part of it might have been, and certainly seems to be, at least for certain facts, that she simply wasn't aware of the record and therefore didn't have the basis to make those objections.
Yes, and next topic, moving on, chain of custody.
Right, now chain of custody is an aspect of authentication which is covered by Article 9 of the Rules of Evidence. If authentication is all about establishing to the jury that an item is what the proponent claims it to be, for instance, if you're trying to introduce a threatening voicemail into evidence in a murder case, you'd have to establish this was a voicemail that was left by the person who is charged with the crime in question. Now, one aspect of authentication is chain of custody. That's the requirement that the proponent of evidence prove that an item being introduced in court is the same item in substantially the same condition it was in when it was taken from the relevant party. Now, this often comes up in drug cases. You might have, say, a person who's arrested. The police take a Ziploc bag of white powder from his pocket. Person is being prosecuted for possession of cocaine at trial, and the prosecution has to establish when they seek to admit the exhibit of the Ziploc bag with white powder, as, say, State's Exhibit Number 3, they have to establish this is the same item in substantially the same condition, and basically, they have to account for each set of hands the evidence went through to show how it went from, say, the police officer to the lab tech, to the forensic expert, etc. Now, chain of custody is something that often gets established quite easily, but there have been a number of cases where it's been called into question. Most notably, you might have heard of the case of the individual doing so-called dry labbing, basically faking test results in Massachusetts, resulting in dozens of convictions being called into question. Now, when it does become a case where you have evidence and you have reason to believe it's either not the same item or it's not in substantially the same condition, you need to be prepared to raise that chain of custody objection, which could result in either A, that evidence being deemed wholly inadmissible, or at least B, the jury seeing there are serious questions about authenticity and thereby maybe having the jury call into question the credibility of that evidence. Now, Susan, we have at least 2 examples of chain of custody issues in this case, and ultimately, however, Gutierrez didn't raise them and they didn't become issues. So what was the first of those?
The first was the windshield wiper versus turn signal debate, which I mentioned earlier. This has to do with whether it was the turn signal or the windshield wiper that was broken in Hayes' car. Now, apparently one of them was, or maybe both, but the prosecution couldn't make up its mind. It presented this question both ways, and witnesses testified both ways. But the only evidence we have that could show whether or not it was the turn signal or the windshield wiper, or possibly both, that evidence consists of a video that was taken of Hayes' car. But that video was taken not when the car was first found, but several weeks later, after the car had been sitting at a repair shop. And Colin, why is that a problem?
Yeah, what we know in this case is that after Hayes' car was in police custody, it was released to the victim's family and thereafter taken to a body shop. We're not 100% sure whose body shop it was, but it does appear to have been a body shop owned by one of Hayes' relatives. And thereafter, for over a week, that car was out of police custody and it was actually outside in a parking lot in the snow before the video was taken.
The other issue, the other big chain of custody issue here, has to do with the DNA evidence in this case. DNA samples were taken from Hay, Jay, and Anon, and eventually, later on in the investigation, the prosecution decided to test some blood samples that were found on a t-shirt in Hayes' car. What's concerning, though, is that when the DNA analyst was looking at this evidence and doing her testing, she noted that the samples for both Hay and Anon samples, although not Jay's sample, had been broken open, which means that at some point in time, in between when those DNA samples were first taken and when the DNA analyst did her testing and received those samples herself, the seals had been broken by an unknown person and for an unknown purpose. Because the chain of custody log for the DNA gives no indication of why it was broken or who would have been doing testing on those samples. This should have allowed Gutierrez to object to the omission of the DNA evidence at trial.
Right, so we have two pieces of evidence. I don't know that overall either of them was hugely critical to the prosecution's case. The broken lever in the car was used to try to corroborate Jay's claim that Adnan had said that Hay kicked the windshield wiper lever while she was being strangled in the car. The shirt with the blood on it was used to show also that the strangulation took place in the car and the assailant used the t-shirt to wipe blood away from Hay's nose and mouth. These really weren't critical issues in the case, but they certainly were issues that helped to strengthen the prosecution case. And in this case, there were grounds to object to both. The car was released from police custody. It was in civilian hands for over a week. The seals and the blood samples were broken, which could have easily led to either cross-contamination or tampering. So at a minimum, what this means is that if defense counsel had made an issue of it, the jury would have seen that there were problems with how the state handled the evidence in the case. And again, that's not necessarily something that would have moved the needle enough for the jury to change from a guilty to a not guilty verdict, but it's certainly something that if you're in a case and you have these issues with regard to chain of custody, you can make the proper motion in limine, and you can seek to have that evidence either excluded or at least called into question in front of the jury. And in this case, defense counsel failed to do either of those.
The next topic is site visits. A site visit is when the fact finder, either the jury or, in some trials, the judge, is taken out of the court in order to physically view a location relevant to the case before them. Site visits are evidence in the same way any other evidence would be, like a photograph or a physical object or even testimony. And they're recognized as a valid form of evidence under the Advisory Committee Note to Federal Rule of Evidence 401. Whether or not a site visit will be allowed is left to the trial court's discretion. The court can decide whether or not to permit the jury to be taken out to view something, but once that permission is given, that is evidence like any other, and the jury is free to use the site visit in reaching a decision. In Anon's case, the defense attorney talked about busing out to the crime scene to show the jury the relevant locations, like Best Buy or Lincoln Park, and Gutierrez even accepted money from her client to do so. But that trip never actually occurred. Colin, what would the value have been of a site visit if one had been done here?
Yeah, so we have two different scenes that were important to this case. We had the alleged scene of the murder and then the scene of the burial. Let's start by looking at the alleged scene of the murder. You might recall that on the Serial podcast, a huge issue that they revisited, in fact, a couple of times was the question of whether there was a payphone at the Best Buy. Because Jay's claim in various statements and his testimony was that, at least when he claimed the trunk pop happened at Best Buy, he got a call on Adnan's cell phone. It was Adnan calling him from an external payphone at Best Buy. Jay then arrived at the Best Buy. Adnan was standing outside at the payphone, and he was standing next to the payphone when Jay arrived. At that point, Adnan went to the Nissan Sentra, he popped the trunk, and that is where Adnan showed Jay the body. Now, what you might recall is that the ultimate take-home from the Serial team, and we've corroborated this through various witnesses as well, is that there was not an external payphone at the Best Buy. There possibly and even probably was one inside the Best Buy, but basically if the jury had gone on a site visit, they would have seen that Jay's accounting of key events in the case, because he didn't see the murder, what he saw was the aftermath, is that it was inaccurate because, in fact, there was no external payphone, and the jury certainly could have used that to discredit Jay's testimony in whole or in part. Now, again, is that enough to move the jury from guilty to not guilty? Not necessarily, but again, if you're defense counsel and you're trying to prove reasonable doubt, in many cases it's not about one huge finding. It's often about trying to prove death by 1,000 cuts, which is to say that every little inconsistency you show can build up, and eventually there'll be some tipping point at which the jury is going to have reasonable doubt and call into question the narrative they're being given by the prosecution. So the utility here is that the Best Buy trip would have shown that Jay's story about basically the heart of the story. The trunk pop, when he saw the body, when he learned of the murder, couldn't have happened as he said it happened. And then, Susan, we had the second part, which you mentioned before, which was the burial scene.
Yeah, and like with the Best Buy, having the jury look at the location would have hopefully shown that there were several flaws in Jay's testimony and shown more clearly why his story doesn't make sense. For instance, the burial site was on a fairly busy road through the middle of Lincoln Park. The actual burial site was not very far off the road, and in fact, with the leaves down in the winter, you could have seen the burial site from the roadside if you were driving by. Taking the jury to the scene would have allowed them to see this and to see, first of all, that the 7 p.m. burial story doesn't make sense given how much traffic was on the road then and how close the burial site was to people driving by. And it also would have allowed the jury to better understand what exactly Jay was alleging happened and why his descriptions of the burial don't seem consistent with the burial site. Obviously, in this case, Gutierrez's failure to take the jury out to the location after taking money to do so is a big problem, but that's one regarding attorney ethics rather than evidence. In any event, the jury never went out to these locations, and these problems in Jay's stories were never explored.
Yeah, and Susan, as you said in the introduction to this section, this is very much a matter that's within the trial court's discretion. I think really the failure here by defense counsel was her failure to explain to the judge exactly why these site visits were important. Again, this was very much a case, as is the case in many criminal cases that go to trial, where the state's case hinged on one key witness, in this case it was Jay, and therefore going to the actual scenes of the murder and the burial would have been quite important to call into question the veracity of his narrative. But if you look at the actual oral motions made by Gutierrez in court, they don't really reflect the importance to the jury of going to the scenes, seeing the physical locations involved, which takes us to the next topic, topic 7, and that involves communicating with witnesses in anticipation of trial. Now, we mentioned before the importance of honing in on the facts and doing a proper pretrial investigation, and a big part of that, in addition to confirming events, such as whether the wrestling match occurred on a certain day, is going out, having your team talk to witnesses, having them share their story, and having an idea of how they will testify at trial. Now, in this case, unfortunately for Adnan, it appears his attorney failed in quite a few fronts in dealing with prospective witnesses in this case. We can see on the slide, one of the examples was that Kevin Urich, the prosecutor in the case, pointed out to the judge that there were 5 witnesses. They'd been subpoenaed by the defense. They had made calls to defense counsel in her office based upon a corresponding letter asking for them to call her office, and yet those calls were never returned. And in fact, as I said, there's these letters that were sent to these witnesses that say, quote unquote, once you receive your subpoena in the mail, please give me, Christina Gutierrez, a phone call. I want to schedule your appearance, and I want to talk to you about your testimony in the case. Well, as you can see, we have the prosecutor in the case saying, I've gotten calls from these witnesses. They have concerns. They've gotten these letters. They've made calls to Gutierrez's office, and yet those calls went unreturned. Now, could any of these witnesses, if they in fact had talked to the defense, have helped in the defense case? It's certainly possible. The problem is, in part, we're not sure entirely who those witnesses are. What I do know is, you might recall I mentioned before Krista, the good friend of both Hay and Adnan. Now, she's actually not one of the 5 witnesses, and we know she's not one of the 5 witnesses because it turns out her subpoena and letter were sent to the wrong address. Specifically, they were sent to the wrong city and zip code. So as a result, she was never contacted by the defense team before trial. Now, as it turns out, as we've mentioned before, she relayed to us a specific recollection of the night of January 13th, getting a phone call from Aisha, again, Hay's best friend, and Aisha telling her that Adnan did not get a ride from Hay because at the end of school, Hay said to him, something came up, I can't give you a ride, I have something else to do. So again, it's partly about properly contacting witnesses, making sure that they call your office, that you're responsive to them. And then Susan, in addition to this issue she had about witnesses whom she had identified and had at least made some effort to subpoena or contact, we have other witnesses in the case whom apparently defense counsel never even contacted.
Well, there's a long list of those, but it's hard to say if Gutierrez ever even learned of many of the witnesses' existence because she never references them, never tries to find them, and never talks to them. The main example of this is Asia, the alibi witness for the 2:20 to 2:40 p.m. time period when the murder was supposedly happening. Asia was never contacted, even though Adnan told his attorney about Asia's letters and about her willingness to testify about where he'd been at the time of the crime. For instance, track teammates who were never contacted, and other students who were among the last people to see Hay alive. All of these witnesses could have been used to establish a defense, either by setting up an alibi for Anon or by showing that the victim was nowhere near Anon at the time of the murder, but none of this was ever done.
Right. As one example, we have the person we've referred to on the podcast as Takara. She sat right next to Hay in her final period class. She was the only one who sat next to her. That class ended at 2:15 p.m., right before Hay supposedly left school. She was never contacted by the defense at all, despite the fact that, if you recall, we mentioned Debbie before, she, in one of her police statements, said that Takara asked Hay for a ride on January 13th and was turned down and told that Hay didn't have time to give anyone a ride because she was picking up her cousin. Again, a potential witness who could have really helped the defense, and yet she was never contacted by the defense as far as we can tell. We also have a person on the podcast we referred to as Anne. She was interviewed by the police on March 2nd, very soon after Adnan was arrested. She was listed as a prospective witness for the prosecution at trial, and yet she was never called as a witness. The notes from her March 2nd interview were never produced, and it seems to me, if you're defense counsel in the case, you have someone whom the state was claiming they might call at trial, and then eventually they're not called. The interview notes from her interview are nowhere to be found. That's someone who might have helpful information to the defense, especially because, like Takara, she was in that same psychology class in the final period, and yet, again, like Asia, like the track teammates, like several other people in this case who might have had vital information, they're simply people who were never investigated based upon a failure of due diligence by the defense team.
The next issue is one we touched on a bit earlier, and that's objecting effectively to trial testimony and to evidence entered in the case in chief. We discussed objections during closing arguments, and many of the same rules also apply to objections to evidence presented at trial. But what Gutierrez probably did the most here to let down the defense was her failure to preserve objections that she was making. She, in her defense, wasn't getting many breaks. The court was consistently overruling her objections without explanation and without reason. However, Gutierrez's repeated insistence on simply objecting and then not saying a word more about the issue left those objections unpreserved and unable to be raised in a future appeal. Now, in addition to Gutierrez failing to explain her objections, she also failed to probe the court into making an actual ruling. Because if the court simply makes a ruling and denies an objection without explaining why it was denied, that's not enough to preserve the issue for appeal. The court has to state its reasoning on the record so that the appellate court can review it later. Simply accepting the court's statement to move along or to get on with it and not pushing the court to make a ruling on an objection isn't enough. It was Gutierrez's job to ask the judge to make a formal ruling on the record, explaining the basis of the denial and why it was denied. We also had a failure here when Gutierrez was either cross-examining or choosing her own witnesses to get the judge to explain why she was sustaining the prosecution's objections to what the defense was trying to do. In that case, Gutierrez had an obligation to make an offer of proof, but she wasn't doing it. This is because if evidence is wrongfully excluded at trial, then in order to be appealable, the defense attorney has to explain what the evidence would have been and why it should have come in. Again, that didn't happen here, and since Gutierrez never explained, in most cases, what evidence would have been presented had the prosecution's objections not been sustained, those issues were waived and could not be part of the non's appeal. So I know one of the big examples of this that I found pretty frustrating comes from the letter that Hay wrote in November or late October of '98 after Anon and Hay's first breakup. Hay had written a note to Anon in class talking about how he needed to get over her and how he shouldn't be, I think the word she used was hostile towards her. Although Gutierrez didn't stipulate the admission of this document like she had with the diary, when the prosecution tried to introduce it, Gutierrez failed to explain the basis for objections to it and why it shouldn't have been admitted into evidence. Now, Colin, what should she have done?
Yeah, this takes us to Rule of Evidence 103, which says that not only do you have to timely object, but you also have to state the basis for your objection. In this case, the objection would have been under Maryland's counterpart to Federal Rule of Evidence 8033. So this is Maryland Rule of Evidence 5-803B3. And basically, the claim here by Gutierrez would be that the letter did not meet this hearsay exception, the state of mind exception. If we look to the state of mind exception, this goes back to the old Hillman case decided by the Supreme Court. In that case, you had a letter written by a person, and it was allowed to be admitted to show that person's future intention. But as subsequent opinions have made clear, in most jurisdictions, including Maryland, the state of mind exception can only apply to your state of mind, not the state of mind of someone else. So you could say, for instance, I'm feeling angry, I'm feeling happy, I'm feeling sad, I'm going to the store, I'm going to break up with you, as Hayes said in this letter, and that's fine. That would be admissible in the state of mind exception. That said, the state of mind exception does not allow you to speak to someone else's state of mind. So the theory is, under the state of mind exception, a person knows how they feel, they know their future intentions, they can express those, but a person can't know what someone else is thinking, or at least that's not deemed to be reliable enough to survive having to go before the crucible of cross-examination. Now, in this case, the letter that's referencing Hayes' statements and her belief that she was going to break up with Adnan, that's fine. That said, she can't talk about how Adnan is feeling about the breakup and how he is handling it, etc., because that's the essence of hearsay. It goes back to that game of telephone you might have played as a kid, and in addition to not being able to know what someone else is thinking or feeling, that statement could very well change its going from one person to another, which is exactly why we have the rule against hearsay. This then leads into topic number 9, and this is a topic which we actually talked about a good deal about last night on the addendum, and we'll be addressing this in more detail in episode 10, and that is the Brady Doctrine. So Brady is a Supreme Court case that actually came out of Maryland. Brady versus Maryland is about the discovery rules, and specifically constitutional discovery. It says that pursuant to the Due Process Clause of the Constitution, even without a request by defense counsel, the prosecution has an affirmative obligation to timely disclose material exculpatory information to the defense. Exculpatory meaning helpful to the defense's case, and material meaning it is sufficient to undermine the confidence in the jury's verdict. Putting that another way, it means the evidence creates a reasonable probability of a different outcome had that evidence been disclosed in a timely fashion to the defendant. Putting that simply, Brady requires the prosecution to turn over evidence. It can be substantive evidence, for instance, another person confessing to the crime. It can be impeachment evidence, in other words, evidence that goes to the credibility of a key witness for the prosecution. And so therefore, if we have witnesses, for instance, witnesses who contradict Jay's timeline and his narrative of the events of January 13th, obviously with Jay being not only a key, but really the key witness for the prosecution, that evidence, if it weren't disclosed to the defense, could form the basis for a Brady violation. And because a Brady violation undermines the confidence in the jury verdict, and because it's constitutionally based, a Brady violation automatically means a new trial, assuming that evidence goes to guilt or innocence. And if it goes to sentencing, it means we have a new sentencing hearing. Now, Susan, in this case, we have a few examples of possible Brady violations, including which ones?
Well, there's a bunch to choose from, but Gutierrez did actually make Brady motions in the lead up to trial. She did try and press the issue of the state's non-production, but she never followed through in a way that actually got a ruling that required the prosecution to hand over the evidence that she was requesting. One of the biggest issues in this case, for instance, was the defense's failure to obtain copies of Jay's statements that were made during the investigation in February, March, April, just before and shortly after Adnan's arrest. Not all of that is on Gutierrez. The prosecution had an independent obligation to produce Brady material, which Jay's statements were, and if the state is refusing to hand over Brady material to the defense, and the defense has no knowledge of that material, there just isn't much the defense can do. Here, though, by the time of the second trial, Gutierrez did have knowledge of Jay's multiple inconsistent statements, and Gutierrez did try to obtain those materials. However, her motions were themselves inconsistent and often confusing in their efforts to try and obtain the documents, and the judges didn't seem to be clear on what she was requesting or why exactly she was alleging it was Brady. As was mentioned, there was a mistrial here, which meant that by the time of the second trial, Gutierrez did know about Jay's multiple inconsistent claims, and she'd even received 3 of the 4 transcripts for Jay's interview. However, there was also a 4th interview, a 4th statement taken on April 15th, which to date has never been introduced and never been disclosed to the defense. We still have no idea what was said in that interview, with one key exception. We know it was inconsistent with his previous statements, which means it was Brady. But Gutierrez never highlighted this fact to the judge, and in her request to obtain this material, she never explained why, constitutionally, the state had an obligation to produce it in accordance with due process.
Right, and as I said before, Brady is evidence that's not disclosed by the prosecution. That could be a late disclosure, but oftentimes it's evidence that's simply undisclosed entirely. This ties back into witness prep and talking to witnesses in advance of trial. If you look at our slide, for instance, other witness statements from police interviews, we have Coach Sy. He was a defense witness, and he made statements that apparently were not disclosed to the defense. Becky, we mentioned before, she made a statement to police in April where she said that Hay told Adnan at the end of school she couldn't give him a ride because she had something else to do. Becky was also a defense witness. So oftentimes with Brady, the defense can make Brady motions. They can claim evidence was not turned over. But oftentimes they have no idea because it is evidence that by definition they haven't seen. But you can certainly minimize the ability of the state to withhold crucial evidence by simply conferring with your own witnesses and asking, did you speak to the police? And then confirming that the police and the state, the prosecutor, in other words, have, during discovery, turned over everything your witnesses have told you about. So this takes us to the 10th and the final topic, and this is the topic that is the hot issue now. You might recall from the very first episode of Serial, and Susan has mentioned this before, Adnan was convicted based upon the state claiming at trial that he had killed Heyman Lee in the Best Buy parking lot by 2:36 p.m., with that Best Buy being about a mile away from Woodlawn High School. Now, after Adnan was arrested, he received letters in prison from Asia McLean, a fellow student. Eventually, McLean claimed that she had seen Adnan at the Woodlawn Library up until 2:40 p.m. on January 13th, and yet her claim over the last 15 years has consistently been that she was never contacted by the defense team. This has led to Adnan filing a petition for post-conviction relief, and specifically his claim is that defense counsel was ineffective under Strickland versus Washington based upon failure to contact Asia McLean as a potential alibi witness. Now, recently, the Court of Special Appeals of Maryland, which is the intermediate appellate court in Maryland, remanded the case back down to the circuit court so that Adnan could file a motion to reopen his post-conviction proceedings so that Asia could testify. Now, there are some issues there as to whether Asia was dissuaded from testifying initially at the first PCR hearing based upon the prosecutor, but beyond that, the key point is the fundamental issue here, assuming Asia is allowed to testify, will the court find that Gutierrez was ineffective based upon failing to contact Asia back in 1999 as an alibi witness? Now, as I mentioned a second ago, as we all know, the bedrock Supreme Court case in ineffective assistance of counsel is Strickland versus Washington, which was decided in 1984. That's the case that set forth a two-step test to determine whether the defendant has satisfied his burden of proving ineffective assistance of counsel and therefore is entitled to a new trial or, under certain circumstances, a new sentencing hearing. The first prong of that test is objective unreasonableness. In other words, the question being, did the attorney's actions or, on the other hand, failure to act fall below the level of an objectively reasonable attorney? And then secondly, the second prong is prejudice, and this is similar to the Brady test. If, in fact, the attorney had acted reasonably, is there a reasonable probability of a different outcome at trial? Now, in this case, we have two issues that are being looked at. The one I mentioned before is Asia, and this gets to basically a key distinction that exists in the case, and that exists with regard to ineffective assistance of counsel. Now, I mentioned before the first prong of objective unreasonableness. What the Supreme Court also said in Strickland is we generally give deference to trial counsel. We're not going to be the backseat driver and look at decisions and second-guess them and say, well, you made this decision, you could have done it better. If you did something else, then that's ineffective assistance of counsel. So, for instance, we wouldn't say in a case that defense counsel was ineffective based upon failing to seek a jury instruction on a lesser-included offense of involuntary manslaughter if the defendant is charged with murder, because you could imagine a defense attorney in that case saying, I prefer the jurors to have basically two options, murder, conviction, or acquittal. I don't want to give them the middle ground of being able to have a conviction for the lesser-included offense. Now let's turn to the context of alibi decisions. It seems basically we have a fine line drawn, and it seems to me to be a fair one. It's one that was mentioned in the very first episode of Serial. It's one we've talked about in the podcast. It's one I've discussed in detail in my blog. And that's to say there's generally no problem with an attorney having someone on their team, such as a private investigator themselves, contacting an alibi witness, talking to that witness, and ultimately deciding this person is unreliable, they hurt the case, I'm not going to call them at trial. And that's because oftentimes alibi witnesses are unreliable. They are the defendant's brother, their mother, their wife, and therefore, as you might expect, they could be biased. The alibi witness might have made contradictory statements. They might very well have a criminal record. So you can imagine any number of reasons to think it would be more harmful than helpful to call an alibi witness at trial, and that's fine. There, in fact, have been a number of documented cases in which an attorney either directly or indirectly talks to an alibi witness and decides they're not going to help the case, I'm not going to call them, and the court is not going to find ineffective assistance of counsel in that case. That said, there's also a strong other line of precedent, and it seems directly applicable to Adnan's case, and that is basically a line of cases that is represented by the opinion of the Fourth Circuit in the Griffin case. And what that line of cases says is, if the defendant tells defense counsel about an alibi witness, that attorney or someone on the defense team has an obligation to at least contact that witness. In other words, what Griffin is saying is, before the defense team can make the consequential decision of whether or not to call an alibi witness at trial, they have to first contact that witness to determine whether that person would be reliable or unreliable, helpful or unhelpful. So basically the lesson here is, if you are involved in a case, whether it's a criminal defense case and you're seeking to have an alibi witness testify, or whether you're a civil attorney and it's a breach of contract case and you're trying to decide whether to have a neighbor testify or a real estate agent testify about the work that wasn't done in the house and the value of the house, your obligation is at least to contact that witness and make a reasonable decision about whether or not to call that witness at trial. Now, Susan, the other live issue that Adnan is currently dealing with is the plea bargaining issue. And so what's going on with that?
Well, formerly, the second part of his claim on appeal involved his claim that he'd asked his attorney to talk to the prosecution about a possible plea deal, and Gutierrez had told him there was not one being offered. However, as it came out, and as the prosecutor himself has acknowledged, Gutierrez never actually approached him, and there was never any discussion about a plea. Now, there's no constitutional right to a plea deal, so Adnan was not prejudiced simply by the fact that, standing alone, no deal was ever offered. However, Gutierrez was constitutionally ineffective for failing to at least speak about the possibility of a deal and to enter into discussions with the prosecution if they were willing to do so. This is also not the first case in which Gutierrez has had this claim raised. In a prior case, she was, as was raised by her former client, the prosecution had actually offered a deal, but Gutierrez never transmitted it to her client, so the client never had a chance to consider it. And that deal, if it had been accepted, was much more favorable than the sentence that was ultimately imposed. It's worth noting, though, that at this time, the appeal has been granted for the court to reconsider Adnan's motion for post-conviction relief, and not long ago, the judge agreed to reopen the hearing for two issues. First, the Asia issue, which we discussed, but also the cell phone evidence, and in particular, Gutierrez's failure to adequately challenge the state's expert or to question the admissibility of the evidence in general, particularly with regards to the fax cover sheet, which stated incoming calls are not reliable.
Yeah, and Susan, both of those claims, I think, have a strong chance of succeeding, and the fact that they both do have a strong chance of succeeding shows how big the errors by both the prosecution and the defense in this case could have been, and it's underscored by the fact that it really is difficult usually to prove a Brady claim or an ineffective assistance claim. Now, the plea deal case that you mentioned was the Merzbacher case. That was also handled by the Fourth Circuit, and obviously, if you're defense counsel, you should at least inquire as to what plea deal might be on the table, and of course, when such an offer is on the table, what a good attorney is going to do is to communicate that to the client. But ultimately, despite the flaws with what Gutierrez failed to do in the Merzbacher case, the court did not grant relief. And really, it's a tough test, frankly, for a defendant to be able to satisfy to prove ineffective assistance of counsel. I've written before about the difficulties Adnan might face on the ineffective assistance plea bargaining issue. The key difficulty being you have to establish, in order to succeed in the ineffective assistance claim, that you would have accepted the plea deal that was secured by your attorney. And in Adnan's case, the difficulty is he has to establish both the prosecution would have offered a plea deal and then that he would have accepted it, which is difficult because obviously he's maintained his innocence over all these years. And so I think overall in the plea bargaining issue, Susan, it's really more a matter of best practices versus acceptable practices, at least under the current law. You're probably not going to be deemed legally ineffective on plea bargaining issues unless your client can affirmatively prove I would have accepted a plea deal. But it certainly seems ethically and responsibly the decision you should make is to seek out the prosecutor on the plea deal, and then when one is offered, to communicate any deals to your client.
Absolutely, and as a result, Adnan's stronger claim by a good margin is with regard to the alibi issue and Gutierrez's failure to contact Asia. But again, as a defense attorney, Gutierrez had an obligation to protect her client's interest, and that included trying to see about whether or not a deal was being offered, which she never did.
Okay, that wraps up the presentation of Colin Miller and Susan Simpson on the 10 evidentiary missteps you want to avoid based on their examination of the serial case, which is the state of Maryland versus Adnan Syed. Once again, they recorded this presentation for LexisNexis, which was a complimentary webinar. If you have any questions about the presentation you heard today, you can see Colin's and Susan's contact information on the screen. I'm sure they'd be glad to entertain your questions. And once again, you can also listen to them on the Undisclosed podcast, and you can see both of them have a blog. Colin Miller's is the Evidence Prof blog, and Susan's is the View from LL2. Once again, this has been a LexisNexis presentation. My name is Tom Hagee with HP Litigation Conferences. We hope you enjoyed it.